The first notice arrived on a humid Tuesday, folded with surgical neatness and tucked beneath my doormat like a threat pretending to be a greeting. It accused my golden retriever, Maple, of persistent nuisance barking and cited a clause from the HOA bylaws about quiet enjoyment. The paper smelled faintly of toner and power. I stood there in the entryway, reading the paragraph twice, then a third time, listening for the alleged racket. Maple slept in a puddle of sunlight, chest rising and falling, the picture of canine peace. A mail truck coughed at the corner. A landscaper's edger whined along the curb. A toddler across the street shrieked with laughter. The neighborhood hummed as neighborhoods do, ordinary and alive. The notice demanded immediate corrective action and hinted at fines. It also carried a signature from the compliance chair, a neighbor I barely knew, but everyone referred to as Karen, because she chaired everything, complained about everything, and wore authority like a sash. According to the form, 3 verified reports had been submitted. No times, no recordings, only checkboxes and a flourish of ink. I started with the obvious. I reviewed Maple's routine, noted her quiet hours, and listened for triggers. Garage doors slamming, the afternoon Amazon parade, sprinklers clicking on like metronomes. Maple barked when a cat taunted the fence or when the doorbell startled her, but it was short, sharp, and over in seconds. Still, the accusation changed how every sound felt. The second notice arrived 5 days later with a fine attached. The letter referenced continued non-compliance and warned of escalating penalties. The tone had hardened. Maple flicked her ears at the rustle of paper, then settled again, unbothered by the drama built around her. I felt something else wake up in me, part indignation, part curiosity. If the HOA wanted evidence, I would collect it. If they wanted compliance, I would show it, but on my terms, with receipts, timestamps, and decibel numbers that could stand in bright light. I ordered a basic sound level meter, set an old phone to become a 24/7 security cam pointed at the yard, and installed a doorbell camera aimed at the street. I started a logbook with columns for date, time, noise, and Maple's response. I recorded the absolute chaos of leaf blowers and the low thunder of motorcycles coasting past the stop sign. I circled periods of silence that stretched for hours. I taught Maple a quiet cue using treats and patience and made it a game. The log filled with proof that my dog was being framed by the soundtrack of normal life. Then I noticed a pattern. The notices arrived the morning after the days when I wasn't home between noon and 3. Those were the hours Karen power walked with a clipboard, inspecting lawns and peering into flower beds. Security footage confirmed it. She would slow at my fence, hover, check her watch, and point her phone as if capturing a crime. Maple would trot to the fence, curious and wagging, and sometimes offer a single bark, the canine equivalent of hello. Karen would record that moment as evidence of persistent nuisance. The third notice threatened a board hearing. The letter carried words like non-compliance, sanctions, and lien. It named me as a problem that needed to be corrected, not a resident in good standing. I ran my fingers over Maple's collar and felt the small metal tag with her name engraved. I decided I was finished playing defense. The next chapter would not be about appeasement. It would be about clarity, control, and a record strong enough to carry the weight of a gavel. Preparation began with a white binder and a trip to the office store. I wanted something that felt official when it landed on a table. The binder grew heavy with printouts, the HOA bylaws, the local noise ordinance, veterinary records proving Maple was up to date and well-behaved, and the training plan annotated with dates. I added snapshots from the camera showing Maple asleep during so-called complaint windows. I arranged the decibel logs against the city's thresholds and highlighted the leaf blower spikes that dwarfed any bark. I included a spreadsheet of every noise source I observed: delivery trucks, yard crews, car alarms, teenagers testing speakers, so the board could visualize what sound actually lived on our block. Evidence works best when it tells a story, so I mapped a timeline. It started with the first notice and ran through each day of logging, tying Karen's footpath to the exact moments Maple acknowledged her existence. I added a map of our street, with arrows for typical traffic flow and stars where noise peaked. On an early morning run, I measured decibels at the corner where landscapers congregated, and the meter spiked high enough to break the HOA's own quiet hours. If they had bothered to apply rules evenly, neighbors helped quietly. The retired couple next door kept a garden and spent entire afternoons outside. They had never heard Maple bark for more than a heartbeat. Another neighbor worked night shifts and slept midday. She reported Maple as a comfort, not a disturbance. They wrote statements. They weren't interested in public drama, but they believed in fairness, and fairness likes paper. I went to the HOA management company's website and learned how the board hearing should operate. Notice requirements, the right to present evidence, and the right to appeal decisions. I discovered a clause the letters never quoted, one that demanded good faith attempts at informal resolution before fines. No one had attempted anything informal. No one had knocked on my door, called, or emailed. Karen had skipped straight to punishment because punishment gave her leverage. The night before the hearing, I rehearsed the presentation like a closing argument. I timed it. I cut any sentence that sounded emotional. This was not about likability. It was about standards and definitions. The dog's quiet was no longer merely a personal truth. It was a documented fact. Maple slept nearby, paws twitching through a dream, unaware that she had become a pawn in a theater of rules. Morning came with a low ceiling of cloud and the smell of cut grass lingering from the crews that rolled through at dawn. I slipped the binder into a tote, leashed Maple for a long walk to drain any restless energy, and returned to dress in something that read as neutral: collared shirt, clean shoes, no slogans. I felt a calm settle in, an anchor that comes when you know the facts are organized and the path is clear. At the clubhouse, folding chairs lined a room that tried to look important, with framed photos of ribbon cuttings. The board table held name placards, a pitcher of water, and a small stack of violation files clipped together with bulldog clamps. Karen sat at the center, posture arrow straight, eyes scanning for advantage. A property manager watched the clock. Other residents sat along the wall, there for their own skirmishes. The meeting called to order, and the script began. The hearing opened with a recitation of my alleged violations, crisp and impersonal, like reading weather data for a storm that never arrived. Karen referenced multiple resident complaints and chronic barking, and then gestured to a folder that contained 3 unsigned forms with identical phrasing. I asked to see the times attached to each complaint. There were none. I asked whether they had measured sound. They had not. I asked whether anyone had attempted mediation. The property manager shifted in his chair and cleared his throat. When it was my turn, I placed the binder on the table and opened to a tab labeled Standards. I walked the board through the city's ordinance defining unreasonable noise and the HOA's own requirement for good faith resolution attempts. I flipped to the decibel logs and security footage screenshots, distributing copies so no one had to crane their necks toward the projector. I kept the pace measured. Every claim rested on a document. Every document wore a date. Karen interrupted to insist that everyone had complained. I turned to the statements from neighbors who had not. I presented the map and timeline, showing Karen's daily route aligning with the reported incidents. A board member leaned forward. Another sipped water without swallowing. The property manager asked whether Maple barked at delivery drivers. I acknowledged the occasional single woof and pointed again to the meter readings, which never touched the thresholds during those moments. I emphasized my training plan, the quiet cue, and the increased exercise routine, proof that I pursued solutions even before the HOA did. Then came the misstep. Karen announced that if Maple ever barked again, she would personally ensure I faced immediate fines. The room stilled. The property manager whispered to her, but the words had already left the station. Her statement revealed two problems. First, fines cannot be issued without due process. Second, she made the violation personal. The board's attorney, present by speakerphone, cleared his throat and reminded everyone on record that enforcement must follow procedure and remain free of bias. A small crack opened in the facade of authority, and light found it. I requested dismissal of the current fines and a formal warning placed in Karen's file for harassment, citing the camera evidence of repeated hovering at my fence to provoke a response. The board balked at the word harassment. But the attorney suggested a compromise, a 30-day observation period with neutral data collection managed by the property manager, not by any resident. If the data showed excessive barking, we would discuss mitigation. If it showed normal neighborhood sound, the citations would be rescinded. I agreed. Karen did not, but her protest landed flat. The observation period began that afternoon. The property manager installed a calibrated sensor at the side yard with a locked case and a log accessible by both of us. The device timestamped every spike above conversational level. My camera footage continued and my logbook expanded. Maple's life stayed the same. Walks, naps, training, small joys. The sensor recorded leaf blowers erupting into weekday crescendos, motorcycles burbling past sunset, a midnight thunderstorm cracking the sky, and exactly 0 periods of prolonged canine barking. 3 weeks in, the property manager emailed a preliminary summary. No sustained barking events recorded. No pattern of nuisance correlated to my address. The data felt like oxygen. I printed the summary and slid it behind the results tab in the binder. The final week passed without incident. Unless one counts the afternoon Karen stood on the sidewalk, arms crossed, staring at the sensor box as if she could glare it into compliance. On day 30, the property manager closed the monitoring period and the board scheduled a vote. The outcome felt obvious, but obvious outcomes sometimes derail in rooms where pride competes with policy. I prepared anyway, because preparation had turned this from a personal annoyance into a case with structure. I didn't know then that Karen would force the conflict past the boardroom and into a courtroom where structure is not optional. The board rescinded the fines by a narrow vote, citing insufficient evidence and the results of the observation period. They stopped short of reprimanding Karen, choosing instead to remind all residents of proper reporting procedures. The letter landed in mailboxes like a sigh, careful, non-committal, the language of organizations that fear escalation. I accepted the result, felt the knot in my shoulders loosen, and took Maple for a celebratory loop around the block. Then escalation arrived on its own. Karen began a campaign of complaints unmoored from reality. Calls to animal control alleging neglect, emails to the property manager alleging aggressive behavior, and a handwritten note on my door warning that she would pursue all remedies. Animal control visited, inspected Maple, and left with a pat on her head and a closed case file. The property manager forwarded the emails, adding a line about unsubstantiated claims. The note went into the binder under a new tab labeled harassment. The tipping point came when Karen approached my fence and clanged a metal water bottle against the pickets, then filmed Maple's startled bark as if she had discovered proof. My camera recorded all of it: the provocation, the reaction, the smug retreat. I compiled the clip with timestamps and decided that waiting for another board hearing would only embolden her. Small claims court offered a faster venue and a narrower question: whether her actions and false reports caused me damages. Damages can be more than money already paid. They can include time spent defending against baseless claims, costs of equipment purchased to protect oneself, and the stress measurable by receipts from training sessions and consultations I would not have needed but for her conduct. I listed them: the sound meter, the camera subscriptions, the time logged responding to notices, the canceled work hours for hearings, the extra training classes to ensure Maple would never be a target. I calculate a conservative figure and added filing fees. The number was less about enrichment and more about boundaries that could no longer be drawn with pleasant emails. I filed the claim on a gray morning and served Karen through the standard process. She responded with a counterclaim alleging emotional distress from living near a noisy animal. The court scheduled both for the same day. I prepared the way I had for the hearing, but with tighter focus: a story arc told through exhibits, each exhibit labeled, paginated, and anchored by law. I printed the city ordinance, the HOA's letter rescinding fines, the sensor data summary, neighbor statements, the animal control clearance, and the video of the fence-banging incident. On the advice of a friend who had clerked in small claims, I practiced stating my claim in under 2 minutes, then supporting it with 3 pieces of evidence that spoke for themselves. Judges appreciate economy. They appreciate self-restraint. I left emotion on the editing floor and kept the leash on Maple's good name short and steady. When I finished, the narrative fit in the palm of a hand: a dog within legal limits, a neighbor who weaponized process, a resident who responded with documentation, a remedy proportional to harm. Court day arrived with fluorescent lights and the scuff of shoes on tile. Cases cycled quickly: security deposits, fender benders, a contractor dispute, each resolved with practical rulings. When our case was called, Karen took her place at the neighboring table, face set in determination. The judge flipped through the filings, eyes moving like a metronome, then looked up with that steady patience people acquire when they have heard everything twice. Karen spoke in sweeping generalities about the peaceful character of the community, portraying herself as its guardian. She dismissed the censor as inconclusive and insisted that everyone knows Maple barked. The judge interrupted to ask for names, dates, and evidence. None arrived. Karen pivoted to feelings: her stress, her headaches, her need for quiet. The judge listened, then asked whether she had attempted any informal resolution before filing complaints. She had not. She called the HOA the proper channel, as if process alone could carry truth. When it came time for questions, I kept mine to 2. I asked whether she had ever spoken to me directly about the issue. She admitted she had not. I asked whether she banged on my fence to provoke a response. She hesitated, then called it a test. The word hung in the air like a confession. The judge took a recess to review the exhibits. The room hummed with whispers and the rustle of papers. I sat very still, hands folded, and watched dust float through a thin beam of window light. The clerk called us back. The judge's voice carried the neutral cadence of someone who delivers outcomes for a living. The ruling came in parts. The court found that Maple's barking did not meet the legal definition of a nuisance under the ordinance. Citing censored data and third-party statements, the court found that Karen engaged in a pattern of conduct intended to manufacture evidence rather than document reality. Referencing the fence video as clear provocation, the court dismissed Karen's counterclaim for lack of proof. Then the court granted my claim in full: reimbursement for equipment and training costs, compensation for lost work hours attending to baseless complaints, and the filing fees. The judge added a narrow, practical instruction: future complaints must be supported by contemporaneous, objective evidence, or they would be deemed harassment. The clerk stamped copies. The sound that stamp made, flat, definite, felt like a boundary poured in concrete. Karen's face registered shock first, then calculation. She gathered her papers with stiff movements and walked out without looking back. The bailiff handed me the order. It was a simple document, but it rewired the power dynamic on our street. Outside, the afternoon had turned bright, as if someone raised the dimmer on the day. Maple greeted me at home with her usual tail thump, oblivious to jurisprudence and human theater. I clipped on her leash and we walked a quiet loop. The neighborhood sounded different, not because it had changed, but because I no longer carried the weight of accusation in every noise. The verdict had not silenced the world. It had simply tuned it to fairness. Word of the ruling traveled the way neighborhood news does, through lawn-side conversations, porch steps at dusk, and the subtle shift in who waves first. The HOA issued a brief memo reminding residents about evidence-based reporting and discouraging confrontation. The property manager quietly retired the compliance clipboard tradition. The board added a line to its procedures requiring neutral monitoring before fines in any noise disputes. It wasn't an apology, but it was structural change, and structure outlives moods. Karen kept her distance. She still walked the block, but her route widened around my fence like a river diverting around rock. There were no more notes on my door. The alley of provocation closed. Some neighbors who had stayed carefully neutral before now stopped to scratch Maple's ears and laugh about the irony of the quiet dog at the center of a noise war. The retired gardeners next door started sharing tomatoes over the fence. The night shift nurse dropped off a thank you card, explaining that the court's insistence on real evidence felt like a win for everyone who just wanted to live without sudden accusations. I stored the binder on a high shelf. I didn't throw it away. Evidence is a story told in neat lines, and sometimes you need to keep the story within reach. But the pages gathered dust, while the life that produced them filled back in with ordinary rhythms. Maple learned a few new tricks and developed a fascination with a patch of clover where butterflies like to pause. I resumed weekend projects that had fallen behind: the garden bed along the fence line, the mailbox repaint, the lingering shelf that needed anchors. On late afternoons, sunlight slanted across the street and turned the cul-de-sac into a soft stage for bicycles and chalk art. The neighborhood sounded like itself again. The money judgment arrived by mail through the court's standard process. A check followed, stapled to a curt note from a third-party service Karen used to satisfy the debt. I documented receipt, filed the paperwork, and bought Maple a new orthopedic bed with a corner of the reimbursement. It felt right that the dog at the center of all of it should receive the most tangible benefit. She slept on it like a cloud had lowered itself to the living room. The larger reward arrived quietly, a reminder that rules are tools, not weapons, and that process can protect the ordinary when wielded with patience. The HOA didn't transform into a warm hug, but it became more careful, more aware that authority must travel with proof. I learned that preparation is a kind of peace, and that peace is not the absence of noise, but the presence of fairness. On the first evening of fall, wind chimes sang a gentle, irregular tune, and somewhere 2 streets over, a garage band stumbled through a chorus. Maple lifted her head, listened, and set it back down. I sat on the porch with a glass of water and watched the light fade. The fence stood quiet, the street steady, the house calm. The world had not become silent, but it had become just, and in that justice, the neighborhood finally delivered what it had promised in the bylaws all along. Quiet enjoyment, earned and defended. 1 page, 1 measurement, 1 ruling at a time. On the first evening of fall, wind chimes sang a gentle, irregular tune, and somewhere, 2 streets over, a garage band stumbled through a chorus. Maple lifted her head, listened, and set it back down. I sat on the porch with a glass of water and watched the light fade. The fence stood quiet, the street steady, the house calm. The world had not become silent, but it had become just. And in that justice, the neighborhood finally delivered what it had promised in the bylaws all along. Quiet enjoyment, earned and defended. 1 page, 1 measurement, 1 ruling at a time.